Hi, everyone. It's attorney Justin Lovely here with the Lovely Law Firm, and we're here for another episode of some live action with the Carolina Justice Report, sponsored by the Lovely Law Firm and South Carolina Law TV. I'm here, of course, with my partner and wife, the lovely Miss Amy Lawrence Lovely. So we're going to talk about another area of law that we practice, and that is prevalent here in South Carolina, that we think we do a pretty good job at. I would say we do. Go to see our 5-star reviews.
Yeah.
See our 5-star reviews and see what others can say about us. But that's DUI defense. So, Amy, tell us about some DUI.
Well, let's preface this entire conversation by saying we do not condone drinking and driving. At all.
Absolutely not.
You know, we live in an age where you can get on, you can pull up your phone and hit a button, and there will be a car that pulls up and gets you and takes you home safely. We hope.
Right.
And so we do not condone drinking and driving. But if you find yourself in a situation where you have been charged with a DUI, we can help.
Yeah.
And so, yeah, go ahead, babe.
I was going to say, here's the first question we always get is, everybody hears, they get scared, I got a DUI, but what is the actual penalty for a DUI, Amy? And you can kind of talk about, first, second, third, if you got multiple DUIs or how high you blow. Go ahead. Talk about it.
So all the laws in South Carolina changed in, I think it was February of 2009. And 10 years seems like a long time, but in the land of law, that's not long at all. And so what the new statute did in 2009, it gave us a tiered effect and a tiered penalty. And so it's whether you were charged with a first offense, a second offense, a third offense, and then what did you blow? Did you blow, less than 0.08 or less than 0.10? Was it a refusal? All these different things. And so those penalties range between, a fine of $992 up to 7 years in prison with a minimum of 3 years, depending if it was like a third or fourth or subsequent offense, and then what you blew. But it can go all the way from just a fine of $992 up to 7 years.
Right. And that's, of course, how high you blow, multiple DUIs. There's a
Right.
lot of factors. When we go through every factor.
A ton of factors. And if you go onto our website, you'll be able to see that tiered effect and like where you fall into that ball game of what you've been charged with.
Right. And every case is different, of course. Now, the collateral consequences of a DUI and how they will affect your life, other than these basic, black and white penalties, is probably the most important aspect of a case. Yeah, so let's talk about that, how it affects your life and your job and so forth.
Yeah. So a lot of times what we see, a big thing is people lose their jobs. If you have a CDL license and you're convicted of a DUI, no more. Your job is gone. No more CDL license. Another thing we see is not just loss of job, but we also see when people are divorced, we see a custody issue, right?
Yep. Yeah.
And then there's this ginormous financial burden that comes with being convicted of a DUI. You're talking about ADSAP, which costs, here in this county, and I can't speak for, the rest of South Carolina, but you're looking at anywhere between $800 and $1,200, sometimes up to $1,400, depending on where you fall in their scale. You're looking at, you have to carry SR22 insurance for 3 years, which is high risk insurance, which is, 3 times what you're paying now per year. And I could go on forever. So there's all these different things that come into it. It's not just about, the criminal aspect, whether you're going to go to jail or not. It's all the other things that come with it, for sure.
And if you are a college student and you're going to go on to greater professional goals in your life, whether that's law school, whether that's nursing school, medical school, pharmacy school, it can mess you up because each one of these professionals, when you get an advanced degree, you have to go through the character and fitness portions, and it could mess you up. So defense is very important. And even, Amy, with the Canadian population that we have come down here, they can be denied re-entry to Canada. So
but we just dealt with this last week. He got denied entry because he'd gotten charged with a DUI down here. Also, if you're convicted of a DUI here and you try to go to Canada, they will deny you. And we've seen it time and time again. Matter of fact, we have an attorney liaison in Canada that we work with when we have these kind of issues.
Right. And believe it or not, Myrtle Beach, we have a huge, people don't realize this, but we have Can-Am days down here, and a lot of Canadians come here to vacation.
So they come here, right.
they come here to play golf, and it's very important. And so, we know the ins and outs, and you just don't want to get caught up in it because, again, these collateral consequences are sometimes worse than the actual underlying penalties. So
90% of the time they are, for sure.
Right. So, Amy, and we always debate this, but I think there's a consensus in our office. What is our number one tip that we would give to someone who is accused of a DUI?
Don't blow.
Don't blow.
Don't blow. So the thing is, the law in South Carolina is not .08, right? .08 is the standard. And the law says that you must, if you're driving in the state of South Carolina and you are materially and appreciably impaired, .08 is just a standard. And so what does materially and appreciably impaired mean? I don't think anybody really knows the definition of that. When we have jury trials, I have this little funny thing that I do, and I always say, the Supreme Court, I remember when they talked about pornography, they said, I don't know how to define pornography, but I know it when I see it. And I think drunk is the exact same way. I can't define really what materially and appreciably impaired is, but I know drunk when I see it. And that's not drunk. So that's kind of my little argument that I do with the jury. But if you don't blow it, and they don't have the evidence to convict you 99% of the time.
And not only don't blow, you don't have to do the field sobriety test. You have the right to remain silent. And of course,
no one understands that.
Yeah.
You can refuse everything. And so that's what I tell people, refuse everything. Because let me just go a little bit further on this. We have clients that blow .03, .04, right? Way below the limit. That's having a glass of wine with dinner. For somebody like me who doesn't really drink alcohol but likes a glass of wine every blue moon, that's .04 is a glass of wine with dinner. And I have seen, and I've had clients time and time again who go in, they're doing the right thing, they blow a .04, and they're still charged with a DUI. We all have this vision that we're all going to go home when we blow less, but that's not what happens. And there's a whole lot of other things that go into factor too. As it sits in your body, your alcohol will go up, and then it comes down after a certain point. That's a whole other discussion, I guess. But so how to best represent yourself and to do the right thing by yourself is not to do anything, to stay silent. You have a right to remain silent in this country, which means you can refuse doing the breath test, and you can refuse to do the field sobriety test, because those field sobriety tests, they are structured for you to fail.
Right.
I mean, I challenge anybody who's watching this right now to get up, stand with one foot in front of the other, like you're going to walk a line, but stand there with your hands down for any period of time. I'm 39 years old. I do yoga on the regular and work out, and it is very hard for me to do. And Lord knows you couldn't do it right now if you had to.
Right.
Maybe if our kid's life depended on it, but that's about it.
All right. And of course, like you said, they're designed to fail, and they're very subjective tests. So it's whatever the officer thinks. I mean, they do have guidelines, but a lot of times we get these cases, we look at it, and we're like, this is ridiculous. It needs to be dismissed.
Yeah.
So now, if you do refuse, now this is another issue, because we have clients who come in, they say, well, I tried to refuse, but then they were bullied into giving a breath sample or bullied into doing some other things by the cops. And of course, we're not there, so they're telling us their side of the story. The officers tell their side of the story, and then we see the truth when we get the videos back. But they will also threaten that, hey, you're going to lose your license if you don't complete this test or you don't blow for me.
Right.
Now, and that is true to an extent, but Amy, kind of touch on the administrative hearing process and kind of what we do and how that kind of works.
So if you refuse to blow in the state of South Carolina, your license will be suspended for 6 months. But we have a way to challenge that. And so what we do is when you are charged with a DUI, you are issued a blue sheet of paper. They're baby blue. They're big. They're not like a little ticket. They're big. That's how you know it. This is what we're looking for when I talk to my clients and potential clients. We're looking for that big baby blue sheet of paper, which is your notice of suspension. And that notice of suspension, when you turn it over, it'll have all this where you can fill out your name, your address, your attorney's name, and all that other stuff. And you send it off with a $200 money order. And what that blue sheet of paper does is it requests a administrative hearing. And so what we do is we go and challenge whether there was probable cause to pull you over to begin with. And if we can't find the probable cause, then you'll get to keep your driver's license. And in the meantime, while we wait for that hearing, you can have what they will give you is a temporary alcohol license. And what a temporary alcohol license says is that you can drive uninhibited in the state of South Carolina until we have that hearing and it's adjudicated.
Right. And it's
we
also
win 99% of those hearings.
Right. Well, one of three things is going to happen. One, the officer won't show up. The second thing, we can pre-negotiate before the hearing, or
yes,
the third
which
thing
is usually what I do.
Decides.
I get a hold of the officer, we talk about the case, and we advocate for our clients for sure.
Right. So this is, we could talk the different nuances. This is just a quick once over. Tell them how we help. So if they're charged, what's the first step they should do, and then kind of how we handle them, and then go from there.
So I tell people all the time, hire a lawyer, and hire a lawyer that does DUI on the regular. And why that's so important is, when the economy gets bad and stuff, people will try to dabble into DUI, and unless you know the nuances of DUI, people aren't very good at it. And so since February of 2009, when all that law changed, it created very specific things within that statute that the police officer has to do. And there's all this case law that's come down in between time, and we keep up with that every day. So I have an email that comes to my email that I have specific with the Supreme Court and Court of Appeals and all that stuff, and it shoots me an email, and it says whether or not we have new case law that's come in. I have a whole book, and I have checklists. So when I look at these videos, I'm jumping ahead of myself, but we know what we're talking about when it comes to DUI. We know all the nuances of the law, and so that's what we're looking at.
Right. When we get those videos back from your discovery request,
right,
we can usually, within the first 10 minutes, we know the way we can
right,
get it dismissed or reduced, and that's or if it's a bad case and the state's done everything they were supposed to do.
Yeah.
And that's and of course every case is different. We can't make any guarantees at all. Everyone's different. But we handle these. You first got your start doing DUI defense, and I kind of fell into it, and we do that as well as our injury practice. But it's what we do.
I think I think it helps, babe. It helps that we both know DUI law so well that sometimes I'll have a video or you'll have a video, and we'll miss something, and so we always have a second set of eyes.
Okay.
On these videos, and
we've always used that team approach. That's kind of what set us apart. That's our practice, right?
It makes all the difference, because there might be some little tiny thing that I missed or you missed that the other will pick up on, and it's a matter of a conviction or not a lot of times.
Right. Well, that, ladies and gentlemen, is DUI very quickly in a nutshell. Now, if you or a loved one are in the Myrtle Beach area or statewide in South Carolina, give us a call if you have an issue like this. We kind of know all the ins and outs. This is one of the primary areas of our practice. You can talk to Amy. You can talk to myself. We make ourselves available to you. We're not going to charge anything to talk to you. And if it's a good fit, we'll be glad to take care of you and help defend you. But, again, don't drink and drive. Call Uber.
No,
we don't condone this.
It would not hurt our feelings one bit if we never got another DUI because they're wearing me out.
You're absolutely right. So, ladies and gentlemen, that's it. That's another edition of the Carolina Justice Report, sponsored by the lovely law firm and South Carolina Law TV. We're glad to talk to you again. Leave us any comments. Shoot us a question. Call us if you need us. 843-839-4111.
When life gets ugly, justice is love.